Hello everyone. Today I'd like to discuss an important issue in relation to the Unnao rape case, which stands as the darkest chapter in the criminal justice system, exposing the dangerous intersection of political power, systematic failure, police atrocities, and a live example of delayed justice. First of all, I'd like to tell you about the chronology of events that on June 4, a 17-year-old girl from Unnao was raped by sitting MLA. FIR was not lodged swiftly, but it was lodged after a self-immolation attempt by the victim at the residence of Chief Minister Yogi Adityanath. After the FIR was lodged, then the trial court convicted the sitting MLA Kuldeep Singh Sengar on December 2019 on the charges of 376 rape, 363 kidnapping, 366 of IPC, and read with section 5C and 6 of the POSCO Act, which deals with the aggravated penetrative assault committed by a public servant. Under the POSCO Act, there are two categories. One is penetrative assault that falls under the category of section 3 and 4, which is punishable under section 4, and the other is that if a penetrative assault committed by a public servant, it falls under the category of aggravated penetrative assault, and which is having a higher punishment up to imprisonment of life. So the crucial aspect of the trial court judgment is that the trial court heavily relied on the decision of L.K. Advani versus CBI, where it was held that being an elected representative exercising constitutional duties, the sitting MLA is qualified as public servant. For the purpose of section 5C of the POSCO Act, which deals with aggravated penetrative assault. Now, after that judgment, the convicted MLA filed an appeal under section 389 of the CRPC, which deals with the suspension of the sentence during the pendency of appeal. So what is shocking is that the Honorable Delhi High Court, while deciding the bail application, granted bail to the accused and considered that the MLA is not a public servant. Delhi High Court relied on the judgment of R.S. Naik versus A.R. Antule, a 1984 judgment, in which the Honorable Supreme Court held that a sitting MLA is not a public servant under section 21 of the IPC. The POSCO Act is not having its own definition. It relied on the definition what is defined under the IPC, CRPC, Juvenile Justice Act, or any other IT Act or any other act, but it's not having its own definition. So under all these four laws, it is only the IPC which is having a definition of public servant under section 21 of IPC, which is not clearly covering, not clearly mentioned that whether an MP or MLA is qualified as a public servant. But there are decisions where the court take an expanded view that MP and MLAs are covered under the broader definition of section 21. So the Delhi High Court went too far on the technicalities rather than protecting the rights of the children. They relied on the technicalities that MP and MLA was not specifically mentioned in the section 21. Hence they give a benefit of doubt to the Kuldeep Singh Sengar, in which that he was only convicted for penetrative assault, which is having a punishment of 7 years under section 4 of the POSCO Act, and held that he was not falling under the category of 5C of the POSCO Act. After this, there was a public outrage, social protest. Then the Honorable Supreme Court, I have a greatest respect to the Honorable Supreme Court, because considering the seriousness of the issue, considering the grave circumstances, the Honorable Supreme Court immediately intervened on the matter, and the state that the very decision of the Delhi High Court, and put the matter for further discussion on January 20th, 2025. So, according to my view, so now the entire incident and scenarios I have explained to you, but now the thing is that if I ask you whether an MP and MLA do corruption, then will they be prosecuted under the Prevention of Corruption Act? Then the answer is completely yes, because the Prevention of Corruption Act clearly mentioned that the MP and MLAs perform public duty and they are covered under the Prevention of Corruption Act. Hence, they will be punishable under Section 7 and 11 of the Prevention of Corruption Act. But if I ask you that whether if a sitting MP or MLA commits an offence under the POSCO Act, will they be punished under Section 5C of the POSCO Act? So here the position is not clear. So decision of the RS Naik versus ARN subject to some correction, and that the decision that relates to a corruption case, and the crux of matters whether sanction was required to prosecute a public servant or not. So that judgment entirely relates on the issue of corruption, but not systematic correct the provisions of the POSCO Act. But considering the whole scenario and facts and circumstances, I always believe that the Honorable Supreme Court could correct this and decide this issue in entirety when they again hear this matter on the next date, because there are various judgments where, like Lok Prahari case, in which that it's discussed specifically about the issues of the functions of the MP and MLA, and they are clearly comes under the category of public servant, because they take emoluments from the state consolidated fund. So there are various, you can say that, provisions which clearly specifies and which give a strong conclusion that MP and MLAs are state functionaries exercising constitutional duties, and they will be covered under the public servant category of public servant. Thank you.